With that, a huge welcome to all of you, both on behalf of Pune International Center, as well as Maratha Chamber of Commerce, Industries and Agriculture. If you could join me to put your hands together to welcome Advocate Ramji Srinivasan. We welcome you to Pune, sir.
Thank you.
And I'll do a brief introduction of the panelists here, or more so the members on the dais. We have Mr. Mukesh Malhotra, whom you all know as the chairperson of Wakefield, but also someone who has been past president of this chamber and trustee of Pune International Center. Because many of you who come from Pune would already know of him, so I would not read the longest bio brief that I have here. Also, Professor Amitav Malik, who is chairing the program today, is trustee of Pune International Center. He is chairperson of the program committee. Professor Malik is Padma Shri, a scientist, a friend and colleague of late Dr. APJ Kalam, an author. Again, many things, but I'll save that for today. Because to begin with, I'll be requesting Mr. Mukesh Malhotra to introduce Advocate Ramji Srinivasan. But before that, if I could just take 30 seconds and explain you about flow of the program. After introduction of the chief guest today, we'll be requesting the chief guest to address the gathering. And if you like, sir, we'll take some question and answers, yes, if that's okay with you. Sure. And then I'll be requesting the chairperson to give his concluding remarks. And I'll come back again to say you thanks as part of vote of thanks. Mr. Malhotra, if I could request you to please introduce the chief guest.
Good evening, friends, and welcome to this talk on the Insolvency Act. It's my pleasure to introduce to you Senior Advocate of the Supreme Court, Mr. Ramji Srinivasan, who is a leading litigation counsel. One of the remarkable facts about Mr. Ramji is that he specializes in acts which most lawyers don't specialize in. He is involved in the company law, telecom, energy, aviation, insolvency, and competition laws, all of which are specialized laws and which require a much better grasp of the overall business environment than normal litigation laws. Also, Mr. Ramji is not any stranger to Pune. He has been here many years ago as a student, as a lawyer, and in the 80s, he visited Pune a few times, but he was quite surprised when he saw the changes in Pune in the last 20 or 30 years, not all to the better, I think. He has successfully appeared in famous spectrum cases in telecom, the gas pipeline tariff case, the electricity parallel network battle in Mumbai, for all the airlines in the Airport Economic Regulation Act, in the steel and cement cartel cases in the Competition Commission and Compat. He has also appeared for international MNCs like Google, Microsoft, Intel, besides several others in antitrust inquiries by the Commission. He's the president of the Competition Law Bar Association and was recently awarded the Competition Lawyer of the Year. He's been nominated as India's representative to the International Competition Network by the Competition Commission of India. He successfully appeared in some of the landmark cases involving the new statute, the Insolvency and Bankruptcy Code. He succeeded in the very first appearance before the NCLAT in the landmark Innoventive matter. I think Innoventive has some connection with the city of Pune. And he was the senior counsel for ICICI Bank, where it was the first major matter where the law in many ways was laid down as far as this act that we're going to hear about is concerned. The decision was upheld by the Supreme Court. He has since appeared in several matters for financial creditors, operational creditors, and companies, promoters, and directors who were subject to orders under the Insolvency and Bankruptcy Code. He advises a large number of IRPs, that is the independent professionals for the restructuring or whatever. He's also been the chairman of several committees of the industry bodies like ASSOCHAM and has advised the government in the drafting and or amendments of various legislations, including the Electricity Act, Data Protection under Information Technology Act, Telecom Regulatory Authority Act, and Competition Act. I think this just gives you a flavor of the kind of very specialized but yet very broad things that Mr. Ramji has been involved with. And it's an absolute pleasure for me to introduce and bring him to you today. I hand you over to Mr. Ramji Srinivasan. Thank you.
A very warm good evening, friends. Thank you very much, Mr. Prashant Girbane, Director, Pune International Center. Thank you very much, Mr. Mukesh Malhotra, my friend, and the man responsible for getting me over to Pune. I prefer to still call it Pune, as you mentioned, that I have my association here since the early 80s. And thank you very much, Professor Malik, and to all of you who've taken time off on a Saturday afternoon to come and hear me on a topic that is certainly not as exciting as many other topics that you would have probably heard in this corridor or in this room. But I must also thank my friend Mr. Anand Jha, advocate. I don't see him somewhere here. Are they? He was instrumental in egging me on when I said that yes, this invitation from Pune, an advocate in the Supreme Court who has assisted me and who is probably more well-versed than I am in this subject. Mr. Malhotra made things easier for me, much that I would not have wanted him to carry on like this. The fallout of his long speech was that my speech can be a little shorter. But he has very kind words to say. Please don't believe all that he has said. I will come straight to the topic. The topic is one that concerns, at one level, the Indian economy. Very few legislations have hit the headlines, have captured business and political attention as the Insolvency and Bankruptcy Code has. Its origins are very small, very recent. It was as recent as in November of 2015 that the Banking Reforms Committee had presented its report. Just before that, the Minister of Finance, Mr. Arun Jaitley, had announced that there will be large-scale action taken on the economic front and the financial front, and that there would be an attempt to introduce a new Insolvency and Bankruptcy Code in the form of a law. And soon thereafter, a flurry of activity happened, leading to both the Rajya Sabha, the Lok Sabha and the Rajya Sabha passing the act, and the presidential assent was received. In the space of about a year and a half, really speaking, there has been such rapid development in this legislation, and I've yet to see any such rapid pace of development in any of the other regulatory laws that I have had occasion to practice in, whether it is telecom, broadcasting, competition, gas, pipelines, electricity. They've been there for some time. But the immediacy of the development, the manner in which this has proceeded, has been occasioned by the trigger of two things. One, that there was this urgent need for the Indian economy to propel forward, and there had to be certain triggers. And one of the things that we had to do was to ensure that we had capital in the marketplace. after 2008, as we all know, if funds inflow into India has been sort of not very regular. It's come and it's gone. People have called it FDI. Some people have called it hot money. Some people have termed it unreliable. So therefore, it was necessary to ensure, of course, recent trends show that there has been more domestic inflow into the marketplace than foreign direct investment or inflows into the equity markets. But one of the other things was what we usually call, how do we monetize an asset? How do we discover that we have money and capital in our own pockets which needs to be deployed and has to be made available? And how do we then get that opportunity back to the industry? And with that motive, I think this act came about. I think the principal attempt and the objective of this legislation was to ensure that there was credit flow back into the market. How do you ensure that credit availability is made available quickly in a time-bound manner from assets which are no longer performing? So therefore, if you have thousands and thousands of crores stuck in as NPAs with banks, both nationalized as well as private banks. The recent study shows that there has been a large amount of NPAs also with private banks, although the original impression was it was only nationalized banks. And also, how to ensure that there was a mechanism whereby there was very swift action taken in respect of an exit option that could be given to failed businesses. So therefore, there was need to go ahead and overhaul about 12 legislations. And that is what has happened in this exercise. About 12 legislations has been overhauled, at least 2 have been repealed. The provincial Insolvency Act of 1909, we've had some of those also, going back more than 100 years old. And several amendments carried out in a whole host of legislations, the Companies Act, the SICA, the SARFACI, the DRT, and so on and so forth, all to ensure that you had this legislation which got the best of all of those and eliminated some of the non-workable provisions. So that's the reason why it's actually called a code and not an act, even though it's an enactment. So it codifies. It sort of brings together the best of all of those and then takes away, repeals most of those portions and then brings them together. So therefore, it is in the nature of, that's the reason why it's called an insolvency and a bankruptcy code. Statistics showed, at least before, and that's the background of this, that India's total bad debts amounted to about 11% of the total lending. That's a very large amount if you were to calculate and share numbers. And they seem to be increasing. Corporate bad debts amounted to about 56% of the total debts of just the nationalized banks, because that was the focus at that time. As I said, subsequently we have information and reports have released that even private banks have suffered equally, if not as much, in terms of NPAs. There were pending litigations, recovery was not possible, exit options were not possible, winding up proceedings took so long. And if a promoter wanted to exit, he had to go through this process and he had to wait in line in the high courts, and therefore the lines were interminable because they had to pay attention to so many other different matters before them. Banks, there were some stopgap, knee-jerk measures that were introduced by way of DRT to ensure how it would be faster for them to have a specialized tribunal to recover instead of the usual high court proceedings for banks. That was an attempt earlier to do this. Then an introduction by way of SARFACI was introduced so that there would be yet another way to ensure that banks got monies faster without an injunction. And therefore, if they were securitized, they were securitized. So therefore, there'd be no injunction if there was an action taken. But all of this still didn't yield the result. All of these examples, these legislations are all experiments and works in progress. As is true of every legislation. Every legislation that the Parliament introduces or passes is at our behest. Our parliamentarians hear our voice and then go back and say, why don't we have a law? And then they debate, and then they pass a law. And then all of those are meant to be sustained over a period of time. You test, you find out if that works or not. If it doesn't, then you have yet another legislation or an amendment. So it's a constant experiment. Supreme Court says that all of these legislations are in the nature of constant social experiments, and therefore they can never be dynamic. And therefore you need to even interpret. Even while interpreting, they say we have to see what is the present status and make sure that we are constantly in accord with our present times. So it took about 4 years on an average to wind up a company. That was the fastest. I mean, most times, I think that's a very, very positive sort of this thing. It took longer than that. The recovery proceedings were either through, like I mentioned, the Contract Act proceedings, suits, etc., and the other acts that I mentioned. There was, of course, and several people will recollect that there was an act called the SICA, the Sikh Industries Provisions Act, under which there were two institutions called the BIFR and the AIFR, which sort of had some familiarity with what we are attempting here, namely that reconstruction of industries. The SICA provisions had a rehabilitation set of provisions. There was an amendment actually proposed to the SICA in 2003, which was never given effect to. The 1956 Act had a corresponding amendment where they thought that when we were to repeal the SICA, we will have those rehabilitation programs and the provisions in the 1956 Act. That was never introduced. Then the 2013 Companies Act came, where the same provisions of rehabilitation were introduced, and also in the 2013 Act. That was also never notified. Ultimately, during that time, the IBC came. And with this, there is a provision which then nullifies and brings into notification the 2003 SICA Repeal Act. So just imagine, so about almost 12, 13 years later, it was given effect to. In that process, there have been some problems. There were some matters that were pending before the BIFR and the AIFR. The transitory provisions are not very clear. And therefore, whatever of the appeals and the proceedings that were pending there at whatever advanced stage, there also, abate. So therefore, there are some writ petitions filed in the High Court, and they are pending, and therefore, they are seeing the government is alive to that situation, and they have brought in some orders to help some of the appeals that were pending. So therefore, we have seen, of course, that there have been a lot of amendments now also to the IBC. We had an ordinance that was not well received, and there have been amendments thereafter also. But I'll come to that in just a bit. So I also mentioned to you those two old acts, the Presidency Towns Insolvency Act and the Provincial Insolvency Act of 1920, which dealt with, of course, individual insolvency. Individual insolvency here in India has not yet been notified under the IBC. There is a provision and a chapter separately for that. Like Mr. Trump, I believe, declared himself bankrupt once, or maybe more. 3 times, that's right. So you can come out of that, and there are jokes around that also. It's a serious subject, but you know, I mean, I think the concept there in a consumption society like that, the concept was that, you know, why worry about debt? That's the advice. You know, when I had little debt, I used to worry a lot. Now I have a lot of debt. It bothers me very little. So that became the concept. You see, the more you borrowed, the more you were into it. Then, so this led to the NPAs, and therefore there were allegations that, you know, funds were freely available, consumption in the industry grew up, there was no accountability, and so on and so forth. There was interference from all sorts of agencies and areas. So that was one. So which brings us now to the situation where after the recommendations that came, one of the things was, how do we ensure recovery? Statistically, and this is again very important, these are the factors that go into it. The recovery rate in India is only about, on dollar denominated terms, 25.7 cents to every dollar. Whereas in the UK, it's 88.6 cents to a dollar. In the USA, it's 81.5. And even in China, it's 36.2. Although there may be other reasons why they don't want to recover in China. They could have made it 100%. If they wanted to. But considering the size of the Indian economy and how it is proposed and is propelled to grow, this, if not addressed, would have certainly caused some problems. The stakeholders in this are not just banks. The stakeholders in this are primarily the industry, which is the backbone of the economy. And the industry will run on two kinds of fuel. One that the promoter brings, and the other, a very substantial fuel that investors, lenders bring. So in India, lenders are not just limited to banks. There are all sorts of types of lenders who come in. And that has also been recognized here. Operational creditors, etc. are also. So I'm so sorry. Am I audible now? Thank you very much. So this came into effect, as I said, in December of 2016, and it is consolidating. The idea basically is to maximize a debtor's assets. At first blush, it seems to be a very drastic act. So what it does is not merely to say that, look, if you are unable to pay your debts, then you are liable to, in the good old days, a notice would go, and then a 433, 434 notice, and then there would be, if you disputed it, then the High Court would examine whether it's genuine or not. Otherwise, a provisional liquidator was appointed, and so on and so forth. The debtor would still continue to remain in possession. And by the time the whole process went through, even if there was an investor, he would come and find there was nothing but shell. There would be a factory, but without equipment. There'd be equipment without the parts. There'd be parts which were rusted. There'd be nothing that he would find. So therefore, who would come and invest? So therefore, the investment and the incentive for anybody to come and invest, to bring in capital, to revive this industry, was completely gone. So therefore, the lackadaisical attitude of the provisional liquidator, nobody would come, and so on and so forth. So it was a very slow pace. But what this act does is two things. One, in the first instance, it says there will be, this is not a recovery mechanism at all. That's very important. The IBC is not a recovery mechanism. It is not a suit for recovery. If you fail to pay your debt and you've committed a default, there are three kinds of people who can invoke. One, of course, is the financial creditor under Section 7, and that's a defined term. Really speaking, they are banks, lenders. The other sort is the ones covered by Section 8 and 9. They are operational creditors. Operational creditors are the ones who are owed money in the course of business, perhaps, or by the company, and therefore there is an admitted default, there is an admitted amount of debt that has to be paid, but they have not paid, so a notice has to be given under Section 8. That's the difference between 7 and 8. A financial creditor doesn't have to issue a notice. If he notices, if he finds that there has been a failure, and there has been a default, and the record speaks for itself, then he can simply go ahead and file. The operational creditor, on the other hand, will have to go ahead and issue a notice first, saying that, look, you owe me money, I'm giving you a demand, within 10 days you have to respond, if you don't, then I will file. The third is a Section 10 where the company itself, the corporate debtor, that's called the CD, can himself go ahead and say, I need. The consequences of all these three actions are broadly that if there is an admission of the petition, then there is a moratorium that follows. So these have to be filed in the scope of the jurisdiction of the NCLT. They call the adjudicating authority here, of the where the registered office of the companies are. So therefore, there is a moratorium. The moratorium is equivalent to the Section 22 of the SICA, namely, no adverse proceedings will be carried against you, no coercive steps, so that the company is protected. It is now placed in this fragile bubble, and nobody, including the financial creditor who has proceeded against the company, can take any steps coercive to the company. What this is intended is that for a period of 180 days, a person called an interim resolution professional, who lasts for about 30 days till he's confirmed by the creditors, and then a resolution professional, who are all recognized and affiliated to the IBBI, that's the statutory body which governs and regulates them under a regulation. They manage the company as a going concern, and then they will go ahead and say that yes, because there is a default, they will invite claims from everybody, and then they will also say that who wants to take over this company, who can pay money to take over this company and its assets and pay off the lenders, because all the lenders now come in, all the creditors come in. Originally, there used to be, at the time of the proposal, that the IRP was required to specify a liquidation value, because he would assess all the claims and assess all the assets and then say, well, I think broadly on an estimate, I think that the company is worth 1 crore or 100 crores or whatever else, just 10 crores maybe, liquidation value. But now, of course, they've realized that that's not a good idea to do that. So therefore, there is an amendment to the regulation which says that should be confidentially maintained, because it led to lower bids. So people started bidding and making offers around that. Well, if in liquidation value is going to be 10 crores, I might as well give you 11 crores, maybe that's worth it, and so on and so forth. So that has been done away with. But the idea was that in that 180 days, no coercive steps will be taken, no suits will be filed, no proceedings will be taken against the company. It will be protected. It moves away from debtors in possession to creditors in possession through the IRP. The biggest fallout, positive fallout of this is that some promoters earlier used to use this opportunity in those winding up proceedings in the provisional liquidator to go away and siphon off the assets of the company, knowing that they can't put in money, the company is going to go under. Why not go ahead and misappropriate all the assets? If somebody wants to come in and then says that, all right, I'll make a bid for it, he'll find nothing in it, and therefore we'll still have profited from our defaults. So therefore that had to be prevented. Therefore, creditors in possession, remarkable change, and the board of directors stands suspended immediately, and therefore nobody can be in control to manage, sell, deal with third parties, which is very drastic. So therefore two things emerge. One, this encourages present management to take note of defaults or demands by third parties very seriously. So therefore you have to be, financial integrity in dealings has to be very quickly addressed. If you have a problem, if you are a going concern, if you are a good company, then go ahead and pay the man, because you owe him money. But if it is disputed, then you have no worries, unless it is in relation to a financial creditor. So operational creditor, people, vendor, he doesn't give you the delivered, the quality, and then he can't go and say, I sent you an invoice, but I sent you rotten stuff. So you haven't, you can't be threatened by him, because but you must dispute it. If you sit tight on it, and then he'll say, no, 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 it was admitted. Now don't go ahead and raise a dispute after I've sent you this event. Although the jury is still out on that, but there are some decisions on this that I will let you know. But the financial creditor is on a different footing altogether. A financial creditor will normally not rock the boat. He's invested large amounts, and he has a contract with the company to pay the monthly installments, the interest amounts, etc. But if there is no financial prudence or discipline, and the borrower, that's the company, disregards its contract and says, I will not pay you your monthly installments or your interests, then naturally there is a default. Then the financial creditor doesn't have to give a notice. He will simply go ahead and file. This could lead to the management being ousted, 180 days in a limbo, and then the promoters will have to come and cough up. But that's not the only thing, because there is no question after admission that you can pay the amounts and then hope that no, everything will be sorted. Once you're kicking this motion, all creditors will now come, all claims will be invited, you have to pay everybody. So therefore, for just, you can't be penny wise, pound foolish. So because you didn't pay that man 10 lakhs of rupees, you will now be faced with liabilities of over, say, 10 crores or 100 crores, and your company is at stake and you're out of management. So therefore, to introduce fiscal prudence, fiscal responsibility, and to take responsibility in running your company well, no point going ahead and blaming the man after he's fled to London. So you have to go ahead and now do it, and therefore you probably have to be very alert about this. So that's the first signal. Secondly, that if you did this, you protected the shares, and then you can get anybody else. Now a third person who's otherwise interested in the company will say, well, the company's assets are all protected, nobody's siphoning it away, I'm not going to find rusty old material here, therefore I am willing to put in my money and pay. Now tell me, if I were to come and rescue, will the banks, the financial creditors, and the others give me an adjustment, a discount? The fashionable term to use these days is haircut. So how much of a haircut are you willing to take? and what kind of a discount can you give? So that happens. So there'll be more than one person who will bid for it and come for the assets. The protection is twofold again. One, the time is now ticking. The clock has begun. The moment that happens, 180 days start from now. There is a provision, you can extend it by a maximum of 90 days. So it's only 270 days. But within a year, less than a year actually, 3/4 of a year, you will have a resolution. That is what the Act expects. You management are ousted because of your folly. A new person comes in. He's certainly going to ask for some discount because he's bringing in the money. Otherwise, the company is going to go into liquidation after 180 days. The financial creditors don't want it to go under liquidation. Everybody's going to get liquidation value. That's not much. This is a going concern. And therefore, they will see value. Therefore, people expect that they will act prudently. And therefore, let somebody else take over the management. Could the promoters, the existing promoters, also bid and then participate and then say, even though we are ousted, we'd like to win back our company? And then if a new investor is putting in about 50% of the amount, we will put in and we will go ahead and pay 51%. Can that be allowed? It could be originally. Actually, under the draft and the notes to clauses of this bill, they said that promoters could also be allowed to bid. Suddenly people realized, look, what's going to happen is the man's going to default. He owes everybody 100 crores. He's going to default. This whole thing goes, and within 180 days, banks are going to say, will you give me 50 crores, and I will offer 51 crores and get back my company. So the ordinance came in. And the ordinance said, no, willful defaulters, people who have not paid their amounts, people who are otherwise discharged or insolvent, etc., and so on and so forth, will not be permitted to go ahead and bid for the company. So the promoters were out. And they thought that that was a good thing, because then genuine people will come in and then go ahead and invest, so these people. But obviously there is a problem to everything that we do in a hurry, including into an ordinance. So what happens if it was never the promoter's fault? And it was a third party's fault. It was something that he didn't do. He was not a willful defaulter at all. And there was a default. Because, mind you, once it is admitted, like I mentioned, it is not possible for the promoter to pay that singular creditor that amount of 10 lakhs of rupees and then drop the whole proceedings and come back to the saddle again. The Supreme Court has said that is not possible. So you have to go ahead. Otherwise, everybody would do this. Then what's the point? So, of course, the Supreme Court says, in exercise of our powers under Article 142, and that means that they've got magical powers. They're like Harry Potter sort of thing. So they can do that, a 142 wand, and say, well, in this circumstances, we find that everybody is bona fide, and therefore we'll allow the promoter to pay. There's a settlement, and we decree that, yes, notwithstanding the law. They have the powers to do that, but that's occasional. They can't do it every day. But that's what Justice Nariman says in one of those decisions, and I'll cite that presently. But for most parts, the promoters are out, the new investors, and he can't come. The ordinance says this. Now there has been an amendment when, in fact, a relative of the defaulter promoter could also not come and then pay the amounts. If I was just related to Mr. Malik and I was his brother, then I couldn't pay and take over the assets, even though the money is coming to the... So that was the kind of disqualification that had been brought in by the ordinance. A little extreme, and also for people.
To prevent the malpractice.
That's right, to prevent all of this malpractice that you go ahead, my wife, my son, everything else, this, that. But they have not sort of diluted that. The amendment has come in. It's recognized that there will be genuine cases. So they have said that, all right, if you are a willful defaulter, you were defaulted because you didn't pay those EMIs and that interest that led to the default. Show me that you are not a willful defaulter. If you want to participate and you pay those defaulted amounts together with that interest or whatever else was accrued, which led to the trigger, get the company back to that position, and now you can bid and see what happens. So that has been the change that has now been introduced by way of this amendment. And they also allowed, of course, that persons related could also bid. And that's why Mr. Mukesh Ambani's got Anil Ambani's Arcom assets. So this recent thing. So that is how it proceeds. So you can see that there is also another thing, which is this is a global approach to it. There is no distinction between a foreign creditor and an Indian creditor. All of them are put together. So one of the other objectives is that this is going to be a collective decision making by the creditors. When we say creditors in possession, it is not just that one creditor, the big creditor, the man who's lent 20%, everybody else is lent 5%, who will call the shots. In which case, there could be a problem again. I only have to get friendly with that 20% chap. So therefore, they say, no, this will now be decided by majority of at least 75% of those who can vote. Therefore, financial creditors having at least 75% of the voting powers, which means of the amounts that are due to them, not claims. There's a distinction in that also, the definition of under 511, 57 read together. So, but that's a matter of detail, and I'm not addressing lawyers here, so I would have been happy to get into those details. So that is the global approach, which means foreign. So therefore, you heard about China Development Bank in that ARCOM case, and they had come in and so on and so forth. DBS, Macquarie had come in, things like this. So that is also, so they all get together, so it's collective decision making, and they will have to decide. But in the process, if the 75% of the creditors decide, then what happens to the 25% creditors? Well, they lose. Because this is about the persons having the maximum financial stake in the company. That's the spirit. So herein lies another very important distinction, which is earlier it was judge-driven, judicial-driven, judicial process-driven, determination, who's right, what is the merits, whether this, that. Now it is no longer. This is decided on a pure, prudent, administrative, financial prudence method. The persons having the largest stake, exposure, they will decide by 75% majority. The IRP will go ahead and work out the resolution process, and they are happy with whatever haircuts that they approve, so be it. Then the matter comes to the NCLT. The NCLT approves it if these conditions have been met. No more. So it is no longer NCLT's province to go and decide, I think that I can invite somebody else. I think that we will do this. I think that this was not considered properly, and so on and so forth. That is not contemplated. Unless, of course, there is fraud. If there is fraud, and the law in India is very clear, fraud unravels all. Everything goes, everything falls. So therefore, that is one really clear aspect. So if that is alleged, then there is a decision, Punjab High Court, where they have said that if fraud is there, then that can be examined. So against that NCLT order, the matter came up to the NCLAT, and they have said that yes, they can examine whether or not it is vitiated by fraud. So that is one aspect. But because of this importance, there is an overriding provision in the Act. That means that notwithstanding anything else, there is a non-obstante clause, as we call in law. Notwithstanding anything else contained in any other provision, the provision of the IBC will override and have effect. Which means that if there is something inconsistent, for example, in innovative, in which I had occasion to appear, one of the grounds that was taken was that there is the Maharashtra Relief Undertaking Act of the 1950s, which was meant to protect labor and employment in such a case. So therefore, as a special measure, the state government would go ahead and pass an order, and therefore no coercive steps could be taken against that undertaking to protect the labor for a year, and it could be extended by another year, and so on and so forth for 15 years. You could actually go on. So in innovative, and we went ahead and filed, and I was appearing for the financial creditor saying that there is default. And so they said, oh, but we've got an order under the Maharashtra relief undertaking, so therefore no steps can be taken and no petition can be filed against us. So that was negative both by the NCLAT and also by the Supreme Court, saying this has got overriding. Therefore, and in any case, that's a state act, and therefore there were other questions, nice constitutional law questions about state power versus federal union power, etc., and so on and so forth. But ultimately they said no. There have been similar instances, Surface Action, RDB Act, and so on and so forth. So therefore, if there is conflict between two, the later act will normally prevail, because Parliament is understood to have known that there were existing laws. Therefore, when they enacted it, they were clear that yes, so what if there were other laws, this will prevail, and so on and so forth. That's the need of the hour. So that I have mentioned. Consequent to this, the IBBI and the provisions, there are about 14 regulations that have been framed in this 1.5 year period of the implementation. So you can imagine at what pace people have worked on it to come with regulation after regulation after regulation to make it work. So it is not one regulation, two regulations. And there are two rules. The central government has also framed two rules together with. So as and when things go along, you can keep on adding and making changes to make it workable. That's the idea. So admission of a matter has consequences, I already told you. The board is set aside immediately and so on and so forth. One of the nice questions that came about in Innovative and the others was, when I file a petition or a bank files a petition and it satisfies the requirements that there has been a default, and I can show it from the records, I don't have to give a notice, then is the NCLT required to hear the other side, that's the defaulting party, before passing an order? So it was contended that no, they don't have to be heard because there is no such provision here. However, the concept of hearing has been introduced now by both NCLAT as well as by the Supreme Court, which says that, by the High Court also in Srinivasan in the High Court, saying that if these are the consequences which are so adverse, then naturally a person must be given an opportunity. Now he will be given an opportunity. So I argued, I said, yes, of course, I mean, if it is going to be a consequence, then he needs to have the minimum ability to come and say, I am not in default. That is all. Not why I am in default. That goes into the merits of the case. Oh, the bank didn't lend in time. Oh, this happened and that happened. There was a strike. Therefore, it's not within my control. I'm a good promoter. Plus, no, but that's not the concept. If you are in default, then you either sort it out with the bank before or before the matter gets admitted. And therefore, there's this period of 14 days and 7 days, etc. And that has been now held to be, of course, directory between the time that they can go ahead and decide the matter. So there is this window of opportunity once it is filed and notice is given that you can go and settle, and that can be withdrawn. Once it is admitted, consequences follow, unless you go to Harry Potter. So that apart, so I've already mentioned about Srinivasan, that's the decision. I've also mentioned that whether it can be withdrawn after that or not. In Lokhandwala, Supreme Court said, no, that's all special. There was also in J.K. Jute Mills a question, what is mandatory period? Should it be done? What happens? Supposing there's a default or there's a defect, should I cure it within 7 days? And if I don't cure it, the petition filed by a financial creditor then falls to the ground. So they said, the NCLAT said, no, that's mandatory. The NCLAT said, well, the 14 day, all of this is very time driven, you see. Everything has to be done very quickly. So the Act says 14 days for NCLT to decide. But the NCLAT said, well, actually it doesn't matter. We're all caught. So it takes longer for us. So even if it crosses beyond 14 days, it doesn't matter. But then there was this question about default. If there's a default, you have to cure it within 7 days. That is, if I file a petition. So I said, well, then, you should give me a little more time also. 7 days is too short. There could be holidays, there could be Republic Day. No, that's mandatory. If you don't file, your petition goes. So that the Supreme Court says that should be treated as directory and should now be that you should give time, provided that it was not willful default again or delay by me. So therefore those are all small little procedural things. Of course, I'm only telling you because some of these are practical problems and they've all occurred. There was also this issue, which is very important, which is in an operational creditor, not financial creditor, supposing one of your vendors, he goes ahead and files a case against you saying that you've not paid his bills. You have to show existence of a dispute. Now, the existence of a dispute, if it pre-exists, the language of the Act was by way of arbitration or by any suit or proceeding. Now, if he has given you a bill only yesterday and you've written to him saying that no, this is not payable, the quality is bad, you've not had time to go to an arbitration award to get it set aside or to file a suit, and he goes ahead and issues a notice, then what do you do? So that has been held to say, well, that is not, it has to be read as, or if you dispute it by a response also, and there is evidence to show that parties were already in dispute, you don't have to show that you went to arbitration or you had to file a suit or a proceeding, because that will be too cumbersome. So I think that was also a saving grace to help the companies and the existing promoters. And there are certain guidelines that it should be a plausible and it should not be moonshine and so on and so forth. It truly exists and so on and so forth. There was another interesting question. Who could issue this notice on behalf of the operational creditor? Should it be done by the company, that is the vendor himself, or could it be done by his lawyer? because under the old 433, 434 notices could be issued by the lawyer also, under the old Companies Act, that you are in default, you have not paid, if you don't pay within 3 weeks, therefore please note that you will be wound up and I'll take action against you. And this will be deemed to be accepted. So NCLAT said, no, you have to be only by that person and not by the lawyer. The Supreme Court now says, of course, it can be by the lawyer also. Because the words used are, it should be delivered. A notice should be delivered to the company. So they use the words used are not issued by. It should be delivered, so therefore it can be. So that's the kind of semantics, but it helps actually, you see, to make it workable. That's really the... Finally, one very important question. Can any of this vendor come back to you and file proceedings after, say, 20 years? 20 years ago, he raised a claim against you and you forgot about it. He also forgot about it. Now the Act says, look, if somebody doesn't pay you your amount and you had raised an invoice, can he go ahead now and get the board suspended and then file these proceedings and then say, look, there was no dispute all this while? There is no limitation prescribed actually in the Act. There is actually no limitation prescribed. So really speaking, the NCLAT came to the conclusion that, well, what can we do? Under the provisions of the SICA, etc., and the others, or the Provincial Act, etc., there was a limitation prescribed. But here, when they repealed it, they didn't put that limitation period here, which means 3 years. Usually you can file within 3 years. So that really means that anybody can come at any point of time. 20-year-old chap can also come. You've forgotten how he looks, but he's now saying that, no, you get off the board. And secondly, they then said, well, these are not really in the nature of recovery, are they? They are not. So the Limitation Act applies only to suits for recovery. He's only trying to restructure because you haven't paid those debts, therefore you're still technically in default, so therefore it should be allowed. But at the same time, in the same breath, they had to reconcile, so the NCLAT said that, well, a Limitation Act is not applicable, therefore anybody can come at any point of time, but we think that he must have some reasonable explanation, therefore latches, etc., we can hold him to it. That's a term where if you're unduly delayed and you've been silent about it, then that means you've slept over your rights, so therefore you're not entitled to. Maybe we will use that against him in an appropriate case if he comes, but I'm only interpreting. And finally, if you have to import limitation, then it should be from, because under the General Limitation Act, from the date when the cause of action arose. So therefore, that 20-year-old chap's cause of action arose to go ahead and file these proceedings to throw you out of the board of directors now in January of 2016 when the Act came. So 3 years from then. So till 19 he can. But after 2019 if he came, then we will say you're far too old, you've forgotten. So but the Supreme Court said no. They have stayed a similar order and they have admitted the matter is still at large. So therefore, we really don't know at the moment if the last word has been spoken as far as limitation is concerned. Frankly, I'm a little scared. I mean, I can't have 20-year-old chaps coming and saying that, no, you really can't. I mean, but that's my personal view. I'm not the Supreme Court. Yeah. So, but but the idea is that you have to, there's a running company. People have forgotten about it. So why should you have him come here and say, no? So then there are these other questions about, how much time and what ads have to be given and so on and so forth. And voting rights, what do they have? Who has the rights? The rights are all based on amounts due and not on claims. There is some matter that's presently going on, so I shouldn't speak too much about it because I'm arguing about that next week, the coming week, where people have said even claims. So therefore, the idea is that you can go ahead, an unsecured person or a person with just claims and no default can then go ahead and control the Committee of Creditors, the COC. And this is very important. Remember, it's the COC which is now determining the fate of the company under the supervision of the IRP. So if wrong voting rights are given to creditors or people who don't have rights in the creditors, then a person can go ahead and potentially vote against a resolution plan and drive you to liquidation. So it's extremely important that the persons who have a voting right as per the Act alone are entitled to vote in the COC for the purposes of calculation of 75%. So that is an extremely important provision. I will mention all that. Then there is, of course, talk about what are the roles and the duties of the IRP and so on and so forth. But those are all things that have been already mentioned. There is, of course, an interesting new case also that I'll mention. What happens if the company is in default and there is somebody who's given a guarantee on behalf of the company, a guarantor. So if all coercive steps have been stayed on a moratorium against this company, then what happens? So the company, the guarantor then, can you proceed against him also and file a proceeding? It seems that you can. And some courts have held, some NCLTs have said that you can. Allahabad High Court has held in a section 10 where the company itself went. That's the Lohia scooters case, LML, Vespa, whatever else, Sanjeev Shreyans. There they said the company itself has gone ahead and said that no, hold me, give a moratorium to me. So in that case, personal guarantors should not be gone and sued. But otherwise, it's a case where independent rights of a guarantor are necessary to be invoked. You have given a guarantee, that man can't pay, there's a resolution that is happening, but why should the guarantor be not held liable? Because if you're talking about fiscal discipline, then everybody should be held to fiscal discipline, that's a contract too. That is when there will be confidence in the marketplace and therefore the capital will keep on moving on and so forth. Then there is one more question. What happens if there is a winding up proceeding already pending in another high court earlier? Now the new act has come. Can the new act and the provisions be invoked? People may come and say, but there's a winding up proceeding pending. A full bench of the NCLT heard me on this point. Of course, I argued, I was appearing for a bank, to say that no, winding up proceedings cannot matter, it doesn't matter unless it's been admitted and a liquidator has been appointed. Merely because it's pending there doesn't mean that you can't have IBC. IBC provisions are independent. Like I said, it's overriding, so therefore it really doesn't matter. I finished arguments and they reserved it in October. And they still haven't pronounced. But in the meanwhile, the Bombay High Court has held that actually you can't stop the IBC. So the IBC has to go ahead unless there has been an order of admission and a winding up passed by a High Court. So therefore, that sort of answers that question. I think that there is also much to say about all of these, but I am going to now only talk about two quick things. One, after the IRP fails in 180 days plus 90 days, then there is a liquidation process. The liquidation process is something similar to the liquidation process that we've already seen in the general. There is an order of priority that is changed from the original winding up proceeding. There's a change now in who gets money first. The insolvency resolution cost gets paid first. So the IRP gets paid first because he's been there for 6 months. The liquidation cost, workmen's dues, wages of unpaid dues, etc. And then debts owed to the government for 2 years. Look, they have gone down in priority than they were before. And then the remaining debts, etc. We still haven't come to that Donald Trump sort of example, namely individual bankruptcy, etc. But those are all, that will happen as and when that is notified. So the distinctive features to conclude are this. One, that this is separate, this is a commercial activity under the aegis of the creditors. The creditor is in control. Strict timelines have to be followed. Cross-border financial institutions are also recognized. There is a collective mechanism of 75%, not individual. And therefore, the amendments now that have been made to all the other acts also go ahead and trigger the mechanism in favor of all of this. The one recent development that I've already mentioned to you about is the ordinance and the amendment that I've already touched upon, but I don't think that I should go on any further on that before you all ask me never to come back to Pune. Thank you so much for your kind attention and thank you for the opportunity.
Well, thank you very much for that very detailed. I'll just say a few comments. It's a very complicated subject, but he made it as simple as possible. Having said that, let's understand that this INB code is essentially, the spirit of it is to understand that every business failure is not a bad thing. And the businesses that fail, some of them will actually they deserve a chance to have a second chance. They deserve a second chance. And therefore, what kind of strategic structuring can be done, and so on and so forth. Unfortunately, in our country, there is almost a presumption that more than 50% is the intentions are not right. And perhaps that's the reason why our recoveries are so low compared to the rest of the world. So there is no solution or there is no silver bullet for stopping fraud. what I hope, I'm not understood fully, I'm not an expert, but my own feeling is that what I hope this INBC will bring about is an alignment or convergence of the motivational gradient of the stakeholders. If that happens, then everybody will be sort of interested together either in reviving the failed business or having a strategic recovery or debt collection. If this kind of alignment can be, what shall I say, institutionalized is too strong a word, but if the, yes, if that leads to that, so always the devil is in the details, so we'll have to see how this act gets implemented, how people receive it, and so on and so forth. So I will take the advantage of being sitting here to raise one question, which is that in our kind of a scenario where a large percentage of such cases, what happens is when the business starts, every intention is good. When it fails, then suddenly the people start wondering, oh, can I get out of it? And can I get out of it maximum benefit? And that is where the problem starts. So is there a way that this IBC will also can be fine-tuned to look into a problem emerging? That's my...
So a problem emerging as in that this is likely to happen, that you are likely to go under.
Yeah.
So what it does is, yes, there could have been instances of warning bells, so to speak, which then before this drastic step happens, people are issued a sort of a warning, and the promoters and the existing board then gets a quick attempt to go ahead and rectify the situation, steer the company back. But I think that at the moment is not envisaged by the Act. But I think more than not, the contractual documents that people have with financial creditors would usually contain a clause which say that yes, you will have notice of the first default, the timelines are such, you will be served with the notice of a second default, and if you default continuously over a period of 6 months or 3 installments or 3 interest payments, only then this will be regarded as an event of default. I think some of the agreements and some of the clauses have this built-in protection. It's not the very first default that happens. The other thing is that the timeline that you have to go ahead and do this is that the financial creditor invariably goes ahead, and one of the things that he does and produces is that he issues a notice and says that you are in default, and that's a legal notice that his department sends. So that serves as an alarm bell again, and he says otherwise I will have to go to the under the IBC. And finally, there is another protection, which is a very short protection. Of course, it's not the kind that you are envisaging, which is that you have this limited period of 14 days within which could be extendable. You can go ahead and still say to the NCLT, look, 14 days is not sacrosanct for you, so please adjourn the matter, and by which time maybe you get a month to go ahead and present a proposal very quickly, and that may be acceptable and it's withdrawn. So a lot of those cases, I haven't given the stats, but I think several cases have been the cases of people having filed, gone beyond 14 days, have been withdrawn because they've been settled. So,
okay, shall we take some questions? Please identify yourself and keep the question to be as sharp as possible. Yes, Kanwinder?
So thank you for your talk. As an engineer, I found it very enlightening because a lot of companies are getting created in Pune. You gave a number of 11% where you said that's sort of the percentage of assets that are in trouble or loans that are in trouble.
of nationalized banks.
Of nationalized banks. This 11%, where do you expect it to be in 5 years' time once this act is fully in play and well understood and the whole machine is driven by this act?
Introduce yourself first. You should introduce yourself first.
Yes, I'm Sanjay Kanwinder, member of PIC.
Yes, Mr. Kanwinder, thank you very much. You see, one of the things, and I didn't mention this, but one of the things that triggered this second phase of headline-hitting news, when the IBC by itself came, there were only a few people who reported about it. But the big-ticket reporting and the headline-hitting happened when the government asked RBI to do something about these NPAs. And then the RBI then went ahead and issued a diktat to the nationalized banks. And they identified about 22, out of which in the first phase, 12 were the ones that they asked them to proceed. The banks were very hesitant to proceed. They didn't want to proceed first. It was a gentle nudge, but they didn't. Then the RBI actually came up with an order and said that you have to do this. That led to exposure and filing of these, which led to more than thousands of crores of just these 12 identified NPAs, which then were filed in different courts, NCLTs, as you have seen. So will there be more? This is the published result as a result of that exercise that the RBI published. Will there be more in the next 4 years or 5 years, you're asking me? I think, like Professor Malik mentioned, the amounts may go up because private enterprises, private banks will also come up, and there will be debts owed from operational creditors also, which, by the way, are the largest number of people filing. Banks don't rush to file. This was filed because the RBI asked them to file, and the big ticket defaulters had to be brought to book and therefore had to have a mechanism to change hands. But the large number of people who file are the operational creditors. So therefore, banks, A, nationalized, private banks, second. Operational creditors, how much is the amount? They're also lenders. How much is the amount that is stuck? We have no idea. As long as it is over 1 lakh of rupees, he's entitled to go ahead and file it. So therefore, like I mentioned, lending, that's a threshold. The lending amounts, the lenders are manifold here. So therefore, there were 3 kinds of lenders. Domestic, foreign, within domestic also there were banks and non-banks also, including vendors, operational creditors. So I expect that with this big ticket NPA, that was the biggest fear that the government also had. Should we go ahead and have these NPAs exposed, even though they say that this is a heritage problem that we have inherited, but still somebody has to bite the bullet. So that was done, and I'm sure Professor Malik will have a view on that also. And I'm glad that that came out of the closet. And I'm glad that somebody has gone ahead and said that yes, we will revive. People will have to. Otherwise, what's the point? All these years, the nationalized banks kept it in their books. It was NPA, but nothing was done about it. Now, hopefully, something will be done, and we will find that that is all monetization. That's the credit being brought back into the system. Very important. And not idly sitting in somebody's cupboard.
Being filched away.
And filched away. Yes, that's right. So therefore, unscrupulous people will go ahead and filch it away.
Just to add to what he said, again, the spirit behind is that the ease of doing business in our country, that confidence must grow. And that confidence will grow only if the debt issues are resolved more transparently, more with less litigation as possible. So I think that's
right.
Yeah. Anybody, please raise your, yeah.
Hi, my name is Hitendra and I was a
Louder.
My name is Hitendra and I was a distressed.
It's not working.
My name is Hitendra and I was a distressed debt fund manager in London, managing about $1 billion fund. My interest in the topic of insolvency is something that I've keenly followed, and I want to take your comment on something that I came across in the case of Ruias, where they have got 2 external funds to bid for the asset that they own. And also they have found a very interesting way of coming around the issue of consent, where they have created a offshore entity where the beneficiary of the trust is one of the sons of Ruia, but because he's a minor, he's a beneficiary, he doesn't have the consent vote. So any comments, reaction on that?
Professionally, I'll be conflicted, so I can't speak. But I can only tell you one thing, which is that there are provisions under in the Act where the IRP can satisfy himself that none of the disqualifications are attracted. So it is for them to satisfy.
Yeah, my name is Vishnu and I'm from public. My question is small 2 questions. Basically, what is the relevance of the SURFASI law in view of IBC? Majority of provisions are in effect. And second question is basically, then till the time when the individual insolvency provisions are getting affected, what is the recourse for any individual as on today to declare himself as an insolvent?
Well, the second question is easily answered. As and when that is notified, as several provisions get activated, that will happen. So it hasn't happened so far.
No, what then? What the other? Is there any other regulatory framework that to declare? I heard from somebody that you can approach DRT. Is it true? There is a mechanism available?
For debts owed to, for debts owed against, that is why you had the original Provincial Insolvency Act of 1920 against individuals. So that was rarely used to declare a person bankrupt. So that bankruptcy was never used to declare an individual bankrupt, those provisions. So that, as and when that is notified, it is likely to be notified once we've got this stabilized. You will find that you will have personal actions also taken. Like Professor Malik again mentioned, this is very important. It is not to be treated as a stigma that yes, you have tried, you have failed, the businesses must be given to somebody else who can do it better, or otherwise liquidation must happen, and then you get back. So you're not a defaulter for life. That used to be the stigma earlier. And second is about SARFAESI action that you mentioned. As I said, it's overriding. So if there is a moratorium that happens under Section 14 of this Act, then no further action can be taken under any other Act to coerce or take possession of any of the assets.
My question is that about 2 years ago, the RBI notified certain debt restructuring schemes, which the key feature of which was that the promoters were allowed to retain control. And if, from what I understand correctly, those schemes are to be reconciled with the provisions of the code and that they still stand. In particular, for instance, the S4A scheme, it allowed the promoters to retain control as a part of the restructuring plan or the scheme. Now, what I would like to know is that the code particularly has, or rather divests the promoters of the control and shifts control to the Committee of Creditors, if I understand right?
Under the IRP.
Yes. So then how would we reconcile the provisions of such schemes and the provisions of the code, since the code seems to have an overriding effect?
Well, you've answered it. It is overriding, so it will operate.
All right. So then
The schemes, the guidelines, the restructuring, the joint lender forum, all of those mechanisms, the CDR mechanisms that were all earlier governed and monitored by the RBI would no longer. They will all have to give way to the new mechanism under the Act.
But they haven't been called back or repealed yet.
Well, I don't think that anybody would go ahead with a JLF or a CDR restructuring program, because even if there is one, there will be several instances where a company might be undergoing a JLF program. But if one of the lenders decides and says that, all right, I've had enough of it and you are in default, then I'm going to go ahead and call it off and say that I'm no longer interested in continuing, he's free to go ahead and file a Section 7 under the Act.
All right. Thank you.
Mr. Malhotra, would you like?
In the nature of things as it stands today, you know.
I agree. I completely agree. And I think they will have to.
It has to be a reasonable this thing. 1 lakh can be owed to, you know, today to just a guy selling you, Radhi paper.
Absolutely. I think from a commercial point of view, from a corporate, yeah, even that much Radhi can fetch you.
For the purpose of bidding, like recently there was a news in ET that Bhushan Steel's value was estimated to be around 10,000 crore, but then the valuers revised it to 20,000 crores.
Well, I think what they have done is that there is this elaborate mechanism that is provided for the IRP to go ahead and determine what could be liquidation value. Now, liquidation value is on the basis of assessments that he carries out. Financial creditors are also free to go ahead and bring their assessors and then give that information. So it is possible that somebody may come, maybe a defaulting promoter may value it lower, so that the threshold is brought in lower, so that any other investor can come in. But on a reassessment, the IRP is free to go ahead and have it revalued. So on a reasonable liquidation value. But that, as I said now, is also to be kept confidential, is not to be disclosed. So therefore, it takes away from all of that.
Yeah, one last question.
Hi, my name is Ameya Kulkarni, and I'll ask a question from an individual investor perspective, an equity investor perspective. So once the petition is admitted, there is no going back. The promoters are basically through. And can I automatically assume the equity owners will get zero once the petition is admitted? Or is it still open to interpretation or negotiation with the creditors? So necessarily the creditors will take some haircut, right? Even if it is just 1 rupee.
The equity participation is, of course, not the same as a lender's participation. So this is that if and when there is anything left, and then the shareholders have to get back their money, if at all that happens. So you'll probably be.
That will never happen. If something is left, the creditors will take it.
That is right.
Creditors always have a.
That's right. So that is the nature of equity participation in any case.
So then what happens to the minority shareholders? They also basically have to forego. So if somebody comes and.
All shareholders, including promoters, whoever has put in money, the scheme is that if there is an amount that is owed to lenders, creditors in possession, then the company goes into liquidation if there is no resolution. So if there is no resolution, then if it goes into liquidation, the liquidation value has to be in the scheme that I had mentioned, the list that I had mentioned, that is distributed. So there is
Anything left, then
if there is anything left, and then that means the company is obviously able to then go ahead and get itself, then it will probably ask for a voluntary liquidation and then say that, okay, I have to go ahead and pay off I have a scheme by which I pay off in proportion to the holding of the equity, return back their monies.
Okay, thank you. I think we had a wonderful evening, very informative. So let's give a big hand to Advocate. Anything you want to say?
Hi, thank you so much. As first, before I propose my vote of thanks, there is one thing I must mention to the chief guest, that there is one thing that hasn't changed about Pune is interest of Punekars in such topics. Yes. Saturday evenings that in other cities might be reserved for whether certain film gets released or not. In Pune, they would still find lots and lots of interest in such a topic. The people who attended today would include the members of PIC. There are members of this chamber. There are certain institutional members of PIC, hence faculty and students of those institutional members. And because we do the public programs, we would also have some members of the public at large. And that's been such a gathering in most of our PIC programs. I'm very, very glad to see an overflowing one. My apologies for those who had to stand. I couldn't interrupt middle of program to ask you to take seats, if any. So please accept our apologies for that. With a huge round of applause to the chief guest, if you could please put your hands together. Thank you. And I'll be requesting the chairperson of the program today, Professor Amitabh Malik, to please hand over a tiny, tiny token of appreciation. Sorry? Yeah, sure. And I thought I'll let him. Also, I'll be requesting the chairperson to hand over the publications of PIC. Yeah. Okay, for the camera. Thank you. I must take another moment and also thank Advocate Jha. Thank you so much for all your help, and it's thanks to you that that we could secure time of Advocate Ramji Srinivasan, which we appreciate how busy it is and what a tiring schedule it must be. Also, we must thank Mr. Malhotra, who is both member of PIC, a trustee of PIC, as well as former past president here. And yes, there are no penalty for clapping, Sanjay. That's true. We thank Professor Malik for agreeing to chair the program, as well as we thank each and every one of you who took your time to come and attend this program, because at the end of it all, the program is for all of you who come and attend it. So thank you so much. And one last thing. Today we heard about Insolvency Act. Tomorrow at 11:30, if you travel to Deccan, and attend a program at Gokhale Institute, you'd hear the Deputy Governor of RBI, Dr. Viral Acharya. That's the other program that Pune International Center is hosting tomorrow. 11:30, Gokhale Institute, Dr. Viral Acharya. Thank you so much. Look forward to see you again. Bye-bye.